So activists and community members along the Wild Coast in the Eastern Cape are not backing down in their quest to stop Shell's seismic survey, which they say is devastating to the marine life and the economy. In fact, they say that the activity also poses a threat to the rights of indigenous people. The matter is now in the court, sitting in Makhanda, the High Court that is, where Minister of Mineral Resources, Gwede Mantashe, was actually grilled for accusing activists of engaging in what he called an apartheid agenda. For more on the court proceedings themselves and many other issues, let's speak to Rick Stone. He's the attorney representing some of the activists and community members in this matter. And Rick, it's great to have you on the program. Thanks very much indeed for making time, sir. So there are various issues being ventilated in this very contentious issue. Among them is whether or not there was enough consultation that took place between Shell and some of the community members that are going to be affected by the survey. Speak to us about what you know about the actual engagements that took place.
Good morning, Ayanda. Good morning to all viewers. Always a privilege to be on Newzroom Afrika. Just for the avoidance of any doubt, I'm not the instructing attorney for the second interdict that came. That was Richard Spoor attorneys. So I was the instructing attorney in the first interdict.
Right.
However, we have played a supportive role, and I am aware of the facts in the second interdict and obviously watched the proceedings yesterday. So perhaps I could even touch on consultation more broadly. So in the first interdict, we saw part of our argument revolved around the real paucity of any meaningful consultation. In that consultation it's more than a mere formalistic approach. It actually entails direct engagement. In other words, you can't just send notices and emails. You must meaningfully attempt to engage. So that never happened in respect of my clients, who are ski boat organizations, Border Deep Sea Angling Association and the Carmel Ski Boat Club. Then in respect of the second interdict and their grievances against any meaningful consultation, perhaps in the second case it's a lot more grave, in that there was absolutely no consultation. So Shell and Impact Africa's own environmental management program makes it plain that these type of seismic surveys do affect subsistence fishers and particularly those coastal fishers along the Wild Coast. Now, none of those communities were engaged. So the position that Shell have taken is that they engaged with 3 of the monarchs, although that in itself reflects significant oversight in that they didn't consult with one of the main monarchs.
Right.
But with that said, it's certainly a entrenched principle of customary law that you consult from the ground up and not from the top down. So yes, there was absolutely no consultation with the affected communities. Many of them only found out about these activities just over a month ago in the first week of November.
Yeah. As you've already pointed out, this is a second attempt to try to stop this activity from going ahead. The first attempt actually didn't go your way because I think the judge mentioned there that the consequences of the activity itself is speculative at best, and I'm probably paraphrasing. With that in mind, what is it about the second application that you reckon is different that will lead to the kind of outcome you're hoping for?
Yes, well, look, I mean, I obviously still have my reservations on the first interdict, and we actually filed our notice of appeal yesterday. Effectively, in the first one, we had to get to court very quickly. We could see from data that's in the public domain that the ship was moving at a rate of knots, excuse the pun, to get into the survey zone. So we had to get to court very quickly. And to do that, it wasn't possible to put in hundreds of pages of expert evidence because then you would have to give your opponents a lot more time in which to respond. So the second interdict had over 200 pages, or just under 200 pages rather, of comprehensive expert evidence from at least 5 top A-rated marine scientists in South Africa. So I think that is what will make the difference. So on the one hand, you've got Shell's own environmental management plan, which makes it quite clear that there is harm to the environment. And then you measure that with the applicant's 190 odd pages of expert evidence, which shows that there is significant harm, and indeed the mitigation measures proposed by Shell are wholly inadequate.
Yeah. Interesting you mentioned that you've already filed a notice for an appeal on the first interdict whilst we wait for the outcome of the second one. Is that a sign perhaps that you're not confident that the second one will go in your way?
No, no, absolutely not a sign. Look, although some of the grounds of argument were the same, I mean, we of course act on our clients' instructions, and your viewers and you might be aware that in the first interdict, we were met with an adverse costs order. So our appeal effectively says that the judge made two wrong decisions. One, he should have granted us return day, a very short interdict, and then both sides would have amplified their papers in that intervening period. And then secondly, that the adverse costs order was wholly inappropriate for public interest litigation.
Among the other arguments being made in court is around the impact that this will have, if it does continue, this activity, the impact it will have on the cultural practices of some of the affected community members, as well as on the livelihoods, because some of them rely on the fish that may very well be adversely affected by the activity itself. Help us understand why that's not enough of a reason, at least from your vantage point, for Shell to stop going ahead with this activity.
Look, you would think that, particularly in a country such as South Africa, we would give a lot more recognition to the rights of indigenous people.
Right.
But indeed, we don't, you know. So I think yesterday's proceedings were very important for jurisprudence in our country and the recognition of the rights of indigenous peoples, the rights of small-scale and subsistence fishers. Of course, one of the applicants in that case, the DSTV community, have already fought a very long and hard and tiresome battle of almost a decade to have their own customary rights to fishing recognized by a court. So, yes, I mean, you would think that the cultural significance and indeed the spiritual and ancestral significance of many of the communities along the Wild Coast would be reason enough to at least get around a table and see if some type of sanity can prevail. But yeah, I mean, we've got to remember we're dealing with one of the biggest petroleum companies in the world, that's well over 100 years old. And I think their track record speaks for itself.
The defense for Shell mentioning that what should have actually happened is that the aggrieved community members and activists should have gone through an internal process to push back against this seismic activity going ahead. Why did you go straight to the courts?
Well, look, I mean, certainly in respect of the first interdict, we had tried to exhaust every external remedy, if you want to call it that, outside of court. We wrote extensive letters to both the Minister of Mineral Resources and Energy and to the Minister of Forestries, Fisheries and Environment, asking them to invoke their legislative powers. They had it within their power to suspend the operation of the right and the commencement of these surveys. Although we got a response from the Minister of Environment, we didn't receive the protection notice which we called upon her to issue. Our letter to the Minister of Mineral Resources and his DG was not even acknowledged. Neither was the follow-up email asking for a reply. So that's the type of attitude that you met with. I mean, in those letters, for example, we asked for confirmation, amongst many things that we asked for confirmation that we could submit the internal appeal. So it's not a case that we didn't try to exhaust any other remedies. I think South Africans have well realized that very often the courts is the only place in this country that you'll get any form of justice. In the second interdict, they made it quite clear, and I mean, rather extraordinarily, Minister Mantashe made his position known publicly via government's own Twitter account. So when you've got the minister accusing these communities, and indeed my clients, of colonialism and apartheid of a special type, squandering under environmental protection, I mean, you can quite clearly see what the attitude of those who are supposed to provide you your internal remedies is. I mean, in that case, it makes it quite clear that the department and Shell are necessary bedfellows, you know, in such a setup. So the court was the only place where you're going to get relief in this type of matter.
Sure. Multiple processes are still underway. There's that appeals process for the first interdict. Judgment is reserved in the second interdict, and the judge mentioning that he's hoping to deliver a judgment soon, whenever that is. I imagine it's sometime next week. What happens if none of these processes go your way? In other words, what's the next step if the court processes don't seem to be working in your favor?
Yeah, well, I think the nature of litigation and court is always a longer marathon instead of a sprint. Interdict is an extraordinary remedy, and indeed courts do grant interdicts and must grant them. But this is just one part of it. If you read the judgment the unfavorable judgment in the first interdict, you'll note that the judge made favorable findings in respect of my client's prospects on judicial review. So a High Court application, which will be launched early next year, to judicially review the granting of exploration rights. So not the seismic survey itself, but the actual right to explore, which was awarded to Impact Africa in 2014 and subsequently has been farmed out to a ratio of 50% to Shell. So that is indeed the further relief that my clients will seek outside of an interdict. And then, of course, there's other proceedings that are in the works in other courts, international courts within the UK and even within Holland. So, I mean, there are many lawyers that are of the view that Shell are in flagrant breach of a ruling by the District Court of The Hague, where they've been ordered to reduce their global emissions across their entire global business by 45% by 2050. So yes, I think there's pressure in the courts all around the world, and I'm sure at least one of the cases will eventually get over the line.
Yeah, and I guess many people are also asking themselves the question why Shell would be looking for more gas in a context where the world is moving further away from non-renewable energy. But thanks for your time. I certainly get a sense that there's still a long road ahead, so all the best with that. Rick Stone is the head attorney on this matter, representing some of the activists, at least with the first interdict, but also having some kind of involvement with the second leg of their fight. Once again, Rick Stone, thanks very much indeed.